Senator Francis Heyliger, you're recognized for your 3 minutes, ma'am.
Good day to my colleagues. Good day to the testifier. I know someone is holding, but good day to the people of the territory. I would like to wish warm, happy holidays to everyone. I am definitely in support of these two pieces of legislation as it relates to Bill 34-0173. I want to say, as we continue to make the individuals whole, that the wrongful taking of the 8% and making sure that everyone gets back their money. I am very happy that we continue to shore up that anyone that might have been left behind or any adjustments that are necessary to be made to make them whole, I am 100% in support of. As it relates to this, I was very happy to assist and participate with the university in making sure and reaching out to those individuals that had already separated from the university that they were in search of. Some 260 people they had to locate to make sure that they got their 8% back. And as an office, we were able to assist them with reaching out to the public. And I want to thank them for sharing the necessary information so we could get it out there. As it relates to the second bill, 34-0144, I believe when it comes to being held responsible for the education of our children, I think in this day and age of the pandemic that we're dealing with virtual learning, virtual teaching, a lot of things that we were not aware of and we had to readapt to, caused quite a bit of issues, especially when it came to the truancy of our children and making sure that they were attending school. But what we have to do is be responsible parents. We have to be responsible educators, be responsible guardians in making sure that we know that our children's education is first and foremost.
1 minute.
With this education, they will be the future of this territory. And we have to make sure that they get all the bit of knowledge that they need to become the next legislators, the next gardeners, the next doctors, the next grocery store clerks. But they have to know what knowledge is. So I am definitely in support of the truancy laws being dated. And thank you so much, Mr. Chair, for the time.
Thank you very much, Senator Francis Heyliger. Madam Clerk, who speaks to Bill number 34-0149?
I do.
Senator Francis Heyliger, please proceed with your introduction.
Yes, thank you. First of all, good afternoon once again to the people of the territory and my colleagues, to the testifier, Supervisor Fox. Thank you so much for being here. We were here a short time ago and we were discussing this bill. And I did appreciate the dialogue that my colleagues as well as the Supervisor of Elections did share with us. This bill has to do with transparency and making sure the public has access to information. One of the things that we're trying to do with this bill is to codify in the code that the information that currently is already online, that it stays there, as well as the additional about 15 to 20% of additional information that this bill requests to be online will be put there in a timely manner. We're also trying to make sure, and for me, the biggest thing has to do with making sure of public trust. A lot of times in our community, we find that we hear a lot of stories about people questioning access to public information, asking the questions, how do we get this information to us? All the levels of bureaucracy at times people have to go through. What this piece of legislation seeks to do is really put timelines as well as who can or cannot access certain information. The legislation, inclusive of the amendment, breaks down a timeline as to what can be online publicly. We also have a section that we will be continuing as to public request for documents where you have to go into the Board of Elections for purposes of certain documents we did not believe should be posted online because they do have signatures and several other things that we also discussed with the supervisor of elections, and we were in agreement with that part. But during the last hearing, the supervisor made it very clear that she was in support of the bill if we did two things. One thing was to deal with removing the timeline as to where they would have to respond to the public. And her other request, outside of the other things we had attempted, we adjusted, her other concern was whether or not the general public should have access to this information versus only registered voters. So I am looking forward to her dialogue. As based on our discussion that day, I stated my case as to where, outside of the other things we amended, those two things I was not willing to alter, and I will continue to plead my case before my colleagues as well as the public. So I look forward to your testimony, Supervisor Fox, and I am hoping that if we get this piece of legislation passed, that the public will feel more confident in heading to the polls, because that is the ultimate objective. Thank you, Mr. Chair.
Thank you very much, Senator Francis Heyliger. I understood that there was a video clip.
No video.
Okay.
I wanted to wait till we gave her a chance to do her testimony.
Okay. All right, thank you. So, Senator Francis Heyliger, you're recognized for your point of inquiry.
Good afternoon, Mr. Chair, to Supervisor Fox. I just wanted to make sure, for the record, clarity. In your previous testimony, you spoke to you had to wait for the Board of Elections to meet on November the 29th and have conversations with them in order for you to bring forward your testimony. In this testimony, you stated that they did not meet, so this is strictly from your office, which is you, the Supervisor of Elections. Is that accurate?
Senator Francis Heyliger, again, based on when we get the bill, there's a process. So the first process was we got the bill, we brought it to the board met, they discussed, which is the same position we're stating now, as when we came on the 9th, we did oppose the bill. They send the bill back. You have 2 weeks. They shared with the board. Again, there's two entities: the office of the supervisor, and not just myself. I have two deputies, and then the board.
So the two deputies had an opinion in this piece. That's
correct. That's
okay,
correct.
Go ahead.
That's correct. Yeah, that's what we do it as a management team. I had that in my testimony. It's a management team, and the majority rules. And all two deputies and myself, we agree.
Thank you, Mr. Chair, for the inquiry.
Thank you very much, Senator Francis Heyliger. Francis Heyliger, you're recognized for your point of inquiry.
I know, through the chair to Ms. Fox, in your testimony, I know you were referencing the 270 days. We did make, the only change we made to this amendment that we shared with you prior, and we did send it to you and you acknowledged that you received it today. We made a change to give you until June the 1st, 2023 on that amendment, because according to the discussion, we did not want to interfere with an election year, because we don't want any excuses whatsoever to say this couldn't be done because it's an election year. So we amended the document to push it all the way back to June 1st, 2023. We did send that to you, and you responded to my office saying you did get it. So I just wanted to know, did you receive the recent amendment with that last change, the only change we made to accommodate your concern?
Senator Heyliger, as you are aware, you submit your testimony from Monday. So
yes.
Sending me a change this morning does not change my testimony, because my testimony was submitted from Monday.
I agree.
Yes, I got a change at 10 o'clock.
Senator.
I got an email at 10 o'clock with the amendment.
Yes. And I do agree with you, but I just wanted to make sure on the record, because during the last hearing, there was a concern that you didn't have the most recent and updated amendment. So I wanted to make sure, for the record, the public is aware that you do have the most recent and updated amendment with a singular change to accommodate your concern of dealing with an election year, and we gave you up until the following year within those first 6 months. Thank you so much, Mr. Chair.
Thank you, Senator Francis Heyliger. Information, Senator Francis Heyliger.
Thank you so much. Record in regards to a statement that was brought up via my colleague in regards to several states that are limiting this just to qualified electors. And in the supervisor of elections testimony, she spoke about California, Illinois, Iowa, Louisiana, Maryland, and she said have the same laws regarding a qualified elector being the only one authorized to obtain voters' registration data. Therefore, it is not deemed discriminatory. But I took the time out to pull up those laws. And for example, California, it says, shall be provided with respect to any voter subject to these provisions, and they spoke about it, but it also continued on. And it says, and to any person of election, scholarly, journalistic, a political purpose, or for governmental purposes as determined by the state, by the Secretary of State. So when you made that statement that only registered voters can get this information, California also continued on outside of that and specifically named specific other individuals. You reference Iowa. The only people that can do this is registered voter. We pulled up Iowa's. Iowa State for voters listing, any person may request of the register and shall receive upon payment of the cost of preparation a list of registered voters and other data of registration, participation in election in accordance to the following requirements of limitations. And then they went on to share what can be on these lists. So what I wanted to put on the record is when you make these types of statements and specifically say that only registered voters can get this information, but I am going to the code for these very same states and they have other information, I'm very much confused by what you're sharing here today. But thank you very much, sir.
Thank you very much, Senator Francis Heyliger.
Because again, if she read in the testimony, I quoted everything that she said from California. And that's how I was telling Senator Johnson about the journalistic part. That's the same statement I went in there. It doesn't say anybody gets it publicly. It says you meet these requirements and you go from there. So it's in my statement, that whole quote from California. And it doesn't say the public. It has specific persons who can get the information.
Okay. Thank you very much. Thank you very much, Supervisor Fox. Senator Francis Heyliger.
Thank you. Point of inquiry through the chair to Ms. Fox. During the last hearing, when we had this discussion about certain information being put out to the public, such as phone numbers and emails, was it not clearly stated that those types of information would not be available to the public? And you also referenced a document that came out in May from the Attorney General's office that stated to the board that they cannot give out that type of information. So therefore, does my legislation now alter that? Because at no given point does this piece of legislation say that information will be given out. And by your own admission in the last hearing, you acknowledged that that information would not be given out when you also referenced the Attorney General's document. Is that accurate?
Senator, the senator asked a question in general, and I was responding to her question. You keep referring, my testimony is clear. It's in there. Your amendment addresses what you want, but I'm saying this is what's public. information. This question was, what is public information from our records? And that's what I addressed.
What's clear?
They weren't addressing your question.
One at a time. Let her finish her thoughts, Senator Francis Heyliger, then you can continue. Supervisor
Again,
Fox?
Senator Francis Heyliger, your statement or your amendment specified what's available and what will not be available. The senator asked particular question, and I addressed her question.
Well, I wanted for public record, because when you responded to her in such a general sense, it gave the impression that all these things could go up online and they're going to be public. But in reality, this piece of legislation does not do that. And it's specifically based on your testimony from the last time and from the reporting of the AG's office. Phone numbers, social security numbers, emails, stuff of that personal nature will never be put out to the public.
Thank you very much, Senator Francis Heyliger. Colleagues, we have exhausted. We have the mover of the bill, Senator Alma Francis Heyliger. I was hearing you so much, I just assumed that you spoke. Senator Francis Heyliger, you may proceed with your 4 minutes.
Thank you so much. Good afternoon again, colleagues. Oh, Lord, I have so much to clear up today. Well, I'm going to get straight to it. First of all, when Ms. Fox spoke about her concerns about the 10 days that we originally had in the piece of legislation, and I made an accommodation and we changed it to 10 business days because that would have given them 2 weeks. Because by her own admission during the last hearing, she made it clear that on average, they're able to complete this within 7 days or less. So at the time, by including business days and basically turning it into 2 weeks, I thought that was fair. But I went a step further. And we took some time out because you keep referencing what other states do. And I was a little bit taken back when in your testimony, you implied that the job of the legislature is not to interfere with administrative issues, but I beg to differ. So let me just share with you 24 states, because out of the 50 states, I got tired by the time we got to the 24th one, okay? Arkansas, immediate access, 3 days, 24 hours. California, their law says 10 days. Delaware, their law says 15 days. District of Columbia, 15 days. Georgia, their law says 3 days. Hawaii says 10 business days. Go figure. Idaho, 3 days. Illinois, 5 days. Kansas, 3 days. Louisiana, 3 days. Massachusetts, 10 days. Oregon, 15 days. I don't want to kill out my time, but we have 24 states where the legislature wrote the law to specify the turnaround time for public information from the Board of Elections. So when you're testifying and say we need to basically keep our mouth shut, I don't agree with that. Now, we also spoke a little bit about this part where you referenced the legislative staff, which was mine. Now, early in my testimony last week, I spoke a little bit about the fact that my employee could not really assist in getting information from me because they could not register to vote. Now, you testified in your testimony quite a bit, which I was taken back because I don't even know where me made a simple sentence like that should have even been part of your testimony, but you chose to do it. You started to speak about the 90 days, but what you were not privy to, my employee relocated here on August the 1st. August the 1st to November would have meant she met the 90-day requirement. Then and only then would she have been able to register to vote. My bill was performed on October the 1st. So during the time period she relocated and we were working on this bill, the fact of the matter is she could not get the information, even though she's been paying taxes here. She could not register to vote to get that very information to assist me to get my work done. You also, because I need to clear up a lot of the things that you spoke about, you also reference a black box. I made the statement that the public, a lot of times, they reference a black box They talk about transparency. And the more we're able to open, the better for them. You spoke about what black boxes are used for, but I want to play a quick little 20-second clip as to where this whole black box thing came from.
30 seconds.
And the very words of the man from ESNS, Willie, the same guy, what he actually was referencing when he spoke to the black box. He was only referencing what a black box does, that it stores data that cannot be changed. Could you play that clip quickly? Because I don't want it to come out of my mouth. I want you to hear his.
Time.
May I conclude, please?
You may conclude. You're asking media to play your 20-second.
It's a 20-second clip, roughly.
Okay, media will go ahead and play the 20-second clip.
A system log. And the purpose of the system, we have in our software what's called a system log. And the purpose of the system log is like the black box on an airplane. And what it does is it records every action and every change that is made to any election results.
That's it. So when he referenced the black box, he wasn't asking about the plane going down. He didn't ask who wanted to see it, who didn't want to see it. All he was referencing is what a black box actually does. So I understand all of your dialogue, but in his statement, he was only saying what it actually does. That's it. But all the other stuff that we went off on really had nothing to do with what he was trying to explain. There are only three things that you attempted to challenge. Number one, in this piece of legislation, you were challenging the time frame of the 10 days. I clearly just started to read to you 24 states where the legislature put a date in place. Your other concern had to do with the time frame of us completing this legislation to give you an opportunity to put the information online. We did an audit of the website, and 80 to 90% of the information is already there. So to appease and to make sure we're being fair, because we never want to disrupt you during an election year.
Senator, I know you're on a flow.
Yes.
Can you please take 30 seconds to wrap up?
Yes.
Because you far exceeded your time.
Oh, thank you. We simply amended it to give you all the way until June 1st, 2023. And the very last part has to do with access to data. And this is the biggest concern. As a registered voter, I can come in. There are 50,000 of us in the Virgin Islands in a population based on the census, 87,000. I can come in and get all of this information as a registered voter. If there's a non-registered voter standing next to me, I could hand it to them right now. If I could be a registered voter and could have malicious intent and attempt to commercialize this.
Time has come. That's your second round of time, Senator. Thank you very much. I know you're passionate about this. Thank you very much, Senator Francis Heyliger. Colleague, Senator Francis Heyliger, you're recognized for your point of information.
Good afternoon once again. I would like to thank my colleagues for their input on this very important piece of legislation. When it comes to the people of this territory, it is important that access to information is there on their behalf. I do not wish to live in a community where people feel that their vote does not count. I applaud our election system for all of their hard work, but I do not agree with several things that was stated in the testimony from the Office of the Supervisor, namely that legislators need to keep their place and basically not legislate. What I will say to the public, whether there are concerns about transparency, there are concerns about a black box, there are concerns about their right to vote, it is their right. And unfortunately, as the supervisor shared, she believes transparency is tied to the process. I believe transparency is tied to the people. So clearly we differentiate on that aspect. But as a representative of the people, I will continue to fight on their behalf to make sure they have access to information so that they can vote accordingly. Thank you so much, Mr. Chair.
Thank you very much, Senator Francis Heyliger.